Sorry.
When we wrote, can I just firstly update you on some of the answers to some of the questions, or some of the questions we were asked?
Yes.
I certainly am not proposing to give a comprehensive. I can't provide everything that's been requested. Three things, though. Firstly, the agreed position, because you will remember that when I was talking about the account being taken of time on remand, my learned friend was sort of indicating he may have something to say. I think we've now spoken. We agree, rightly or wrongly, that the position was that no account was taken of time on remand because of the fact of the minimum was just applied and there was no deduction. We are getting to the bottom of the source material that it would explain that approach. It would appear, but we're still locating all the material required, that the reason for that is that Jamaica is a system like England used to be, for example, where a judge has to order a deduction of time spent on remand, and obviously if there's a minimum, there's a minimum. So that's the first thing. Second thing, just really to which I mention now because it obviously we can provide this if it would assist the court. Both sides, as I understand it, and I'll be corrected by my learned friend if this is wrong, have gone back again and looked for 13.3K cases. There is nothing, I think, either side is consistent with what I said, being able to locate in the Court of Appeal, which is what I understood the position to be. What both sides have located is that there is a Supreme Court, which is effectively first instance court, judgment dealing with, in fact, it seems to, on a quick read over lunch, 13.3K2, which is the right to education. We can provide that if it will assist, but I'm not sure it necessarily will. But I didn't want to sort of give an incomplete picture. So that's where we are. Obviously, both sides, I suspect, certainly our side, have reached out not only to the internet but also to contacts they have in Jamaica to try and locate that. Thirdly, in response, I think, to an early question from my Lord Sales, we've been back through our statement of case. Our statement of case does not expressly refer to the provision that mentions dignity, but we do highlight at numerous places, or a number of places rather, not numerous places, in particular paragraph 20 of our statement of case, the fact that there is a link in our submission between dignity and best interests.
Just before you go, Mr. Sunday, were there any, as it were, preliminary papers or white papers or anything of that kind dealing with the content of the charter prior to its formal measuring up? And if so, did they deal with the content of the various rights protected and to be protected?
My learned friend, I think, is not. I understand that there was. I'm not sure.
Are those permissible aids to interpretation? But without a look to see whether they help you or don't.
No, well, I mean, inevitably, to some extent, they must be, because they give some indication of what the framers' consideration were. One of the reasons, in one sense, why in our submission, though, they may be of a limited assistance is, and I was thinking about this over lunch, is that the framers, one can assume, thinking about the date on which the Charter was enacted, would have been well aware by that stage of the case law regarding the interpretation of constitutions, because that case law dates back many years and is well established. In light of that, and given the focus must ultimately be on the language of the provision, if one has a provision which, for example, refers in general terms to a right that is well established in international law, and so can be read consistently with that right, one ought to be able to assume that the framers at that stage were well aware of that law and were not seeking to exclude that.
Without looking at the documents, it's really difficult to anticipate what was there and whether it would be of any assistance.
Well, all I'm very conscious of is that is the judgments of the Supreme Court relatively recently on the importance of focusing on the language of provisions, and that's why I was starting with it. If you look at the language, and then particularly if you've got a provision which adopts the language expressly of a provision of international law, then that's important. Actually, can I, while my Lord is asking me a question, can I just make one point? I'll come back to this as well, actually, in answer to a question. I think I conceded, and I'm reflecting on it over lunch, I'm not sure it's quite as clear as this, that the Paraguayan case was about preventative detention. I'm not sure that's quite as clear, having gone back through it. I have to say it's not brilliantly clear either way, but there are indications that it may not just have been about preventative detention. My Lord and my Lady, when we broke, I was just looking at Boyce. Conscious of the time, the real point I wanted to make about Boyce was that in paragraph 28, which is 767, the court looks at what I've described as the living instrument principle, and in particular says this, just below letter G: judges in giving body and substance to fundamental rights will naturally be guided by what are thought to be the requirements of a just society in their own time. And I highlight those words because one of the reasons why in our submission the presumption in favour of compliance with international human rights standards exists in one sense is because those standards might well be said to be a consensus, essentially, reached by states as to what the standards of a just society are. And when one looks at something like the best interest child, which, as was made clear in ZH, is adopted in one form or another, it's not identical language, but is adopted in numerous international instruments, the point becomes even clearer that that is something that the international community has recognised should be a feature of the legal systems of just societies, to use the language of Boyce. So, in principle, and I'm going to, conscious of time, so in principle our position is you need to give the Constitution a generous interpretation. You need to, when interpreting it, to consider whether the provisions reflect specific obligations of human rights treaties, and we submit the Charter does, for reasons I'll come to. If that's the case, then relevant case law clearly needs to be given particular weight, as has been recognised in the case law of this court. Even if that's not the case, international law will generally be applied unless there is clear language to the contrary. And one of the reasons for that is the point I've just made, which is that those instruments give a clear indication of what the standards of a just society are. Finally, obviously judgments of the international courts are of some significance, partly because it would be, as has been also said in jurisprudence of this court, it would be surprising if standards varied significantly. With that in mind, can I just refer the court firstly to the American Convention, and in particular Article 19, which is at page 475. That uses the language of measures of protection. It provides that every child has the right to measures of protection. The language, essentially, we would say, that is found in the Charter. I would also remind the court essentially of the UN Convention, which was ratified in Jamaica, obviously in 1991. Article 3, there's been discussion of, is the best interest provision.
Just before we move away from Article 19,
sorry, Neil.
Page 475.
Yeah.
Every minor child has the right to measures of protection required by his condition as a minor. So this is very broad, as I understand it. It's talking about a right by the child to treatment on the part of his family, society, and the state. Is that right?
Yes, it is broad, but my lord, if one goes back to the Constitution or the Charter, that language of family, society, and state is present. If one goes back to 296, you see the right of every child. Minor isn't used there. To such measures as are required by virtue of.
Interestingly, they've changed the language a little bit.
But I mean, one could say that the language is just a modification of the language, because status is arguably a more modern way of referring to condition.
No, well, it may be that nothing very much turns on this, but Article 19 is referring to what children have a right to respect from their family, society, and the state. Section 13(3)(k) is referring to the rights of the child, both by virtue of being a minor and as being part of family, society, and the state, i.e. it's the right of the child as located in those entities.
Well, my lord, if anything, that indicates that the Jamaican Charter is broader, because it, on the face of it, would suggest you get both a right as a minor and as a part of family, society, and state. But
at any rate, you accept that I'm reading it in the right way as I was putting it to you.
Well, there are obviously minor differences, but the broad. I mean, the point we're making is that the broad language is the same. It is referencing the need for measures of protection, and it's referencing those need for measures of protection to the fact that someone is a child who also is part of family, society, and state.
Article 19 is very similar to Article 24 of the ICCPR. It's almost word for word. And you mentioned earlier the guidance that had been given by the UN Committee on Human Rights in relation to that article, which I found quite helpful actually to look at. I don't know if you've got it in the bundle. I'm looking at the general comment number 17.
I haven't got general comment number 17 in front. We put in a different general comment which dealt with this specific issue. I think we put in our general comment 24, possibly.
Fine.
Yeah.
Thank you.
Because I think there is a specific general comment that deals with the issue of minimum sentences, and that's what I think from memory. It's the number is 24, and I'll come on to that in a moment. But one of the reasons why, though, in one sense, we started with the American Convention is that, unlike, for example, the ICCPR, the American Convention, in one sense, seems to more closely reflect the structure of the Charter, because in the Charter, the only express reference to children is the provision we've all seen, 13(k), and that, I think, is the position in relation to the American Convention.
Yeah. Well, general comment 24 that you've put in is concerned with something different. That's the Committee on the Rights of a Child. Giving guidance in relation to the UNCRC.
Sorry. Yes.
I don't think you put it in, but I happen to. You find it in 2 minutes on Google. There's the ICCPR committee is the Human Rights Committee.
Yes.
And their general comment number 17 discusses Article 24, and it's quite useful. It says, paragraph 3 says that in most cases the measures to be adopted are not specified in the covenant, and it's for each state to determine them in the light of the protection needs of children in its territory and within its jurisdiction. The committee notes in this regard that such measures, although intended primarily to ensure that children fully enjoy the other rights enunciated in the covenant, may also be economic, social and cultural. For example, every possible economic and social measure should be taken to reduce infant mortality and to eradicate malnutrition among children, and to prevent them from being subjected to acts of violence and cruel and inhuman treatment, or from being exploited by means of forced labour or prostitution, or by their use and illicit trafficking of narcotic drugs, or by any other means. In the cultural field, every possible measure should be taken to foster the development of their personality, to provide them with a level of education that will enable them to enjoy the rights recognised in the covenant, particularly the right to freedom of opinion and expression. Moreover, the committee wishes to draw the attention of states parties to the need to include in their reports information on measures adopted to ensure that children do not take a direct part in armed conflicts. So those are so we see it partly as ancillary to the substantive, to the other rights guaranteed, and partly as giving rise to additional rights, of which they've given these examples.
Well, I'm not suggesting it's not a very wide-ranging provision. It clearly is intended to be a very wide-ranging provision, and again, in one sense, returning to a sort of an area where which I've emphasised, which is the Inter-American Committee. The the Inter-American Court talks about how what it's intended to do is both what the overall intention of that provision in the inter-American system is intended to be, is that it's intended to make it clear that children enjoy the rights of others as well as specific additional rights, but those specific additional rights may well be quite wide-ranging. In one sense, the reason why we focused on the materials we have done is because they specifically look at this context effectively, and how this context.
Still, the examples they give are all of the adoption of positive actions to protect children's rights.
Well, in one sense, I mean, if you think about this system, this case, in one sense, what we're arguing for is a positive obligation, because we're arguing for the need to take account of the best interest of the child. I mean, I'm always a little cautious about going too far down the positive and negative obligation rights, because it can be very difficult to distinguish between them. But what we're saying, in one sense, is that there is. I mean, what all of those. There is material, and I will try and take you to it very quickly in a moment, that talks about how the role of the state, I think it's again the Inter-American Commission or the Inter-American Court talks about how the role of the state is, and I may be paraphrasing a little bit, but hopefully not inappropriately, is to foster the development of children. Now, if you look at those rights, they're all in one sense about the fostering of the positive development of the child. Why does healthcare matter? Because it allows for the development of the child, and that's really what we're saying, is that even in the criminal justice system, you have to take account of that need to foster the development of the child.
In this case, didn't the judge take into account the interests of the child? He wasn't able to implement them, but he took them into account.
Well,
and the legislator had imposed a different set of criteria, which is a criteria of a deterrence facing the awful problems that exist in Jamaica. And so the judge did take them into account in the sense of he assessed them, but he wasn't able to implement them. And that then leads you straight on to whether the punishment is grossly disproportionate under Article 13.6.
Well, my Lord, it depends on whether or not it comes back to whether or not 13.3K brings some it brings some freestanding rights, and that we would say 13.3k required account to be taken, and I wouldn't accept the characterisation of that my Lord has put to me of the approach of the judge, because when I say he didn't take it into account, what I'm talking about is what he took into account when actually setting the final figure. And what he does, understandably, I'm not being critical when I say this, but what he does is say, I recognise that child welfare is something normally I would have taken into account, but I can't reduce the sentence in this case. I can't do anything with the sentence in this case because of the minimum. And so his ultimate reasoning is, all I can do here is apply the minimum. So,
but in sentencing a child, you have to still take into account deterrence, and the legislator has a role in actually fixing what the deterrent element is, and so that's what it does in setting a minimum sentence.
Well,
and provided it's not grossly disproportionate, it's constitutional.
Well, for the reasons I've indicated, I don't accept that, partly because we would submit that 13.3k requires, requires separate consideration of the best interest of the child. So it's not constitutional if it can't be taken into account. But more fundamentally, it goes back, and at the risk of repeating myself, our position is that it's perfectly legitimate for the legislature to give some indication, essentially, of the seriousness of the offence and how it should be dealt with, and the weight to be potentially given to deterrence. But you still ultimately have to have a system which allows the best interest to be taken into account. If this was a guideline which was applied taking account of the best interest of the child, the constitutional arguments we rely upon would fall away. But that's clearly not how it was operated, and not how it appears to operate. Well, I'm conscious of the time. I've got 5 minutes, and I'm way behind.
Yes.
So I'm going to.
Well, you can rest assured that we will. Obviously, we've all read your case.
Yes.
And we'll work through the materials that are referred to in your case in support of the submissions that you've been making.
Yes. Can I just, in the 5 minutes I've got left, refer the court firstly to the advisory opinion of the Inter-American Court, which is at the relevant passages start at 2628, paragraphs 40, 41, and 53. It's paragraph 53, which is the passage I referred to in response to a question from my Lord Reid, a moment ago, which was about the need, about the UN general commentary, and that's where it talks about, the Inter-American Court talks about the need for, the objective rather of protection of children in international instruments being the harmonious development of personality and enjoyment of recognised rights.
When you said before the short adjournment that the measures of protection to which 13.3k is referring are, and you listed four of them, had you drawn those from this paragraph 53 or from some other?
We also drawn that from the juvenile justice, well, from a couple of sources really. Primarily, paragraph 56 is where there is the first reference by the Inter-American Court to the need for the best interests of justice. The second source of those provisions essentially is the Juvenile Re-Education Institute case, which is, well, the relevant passages start at page 2316. And I refer the court in particular to paragraphs 147 and 148.
Give me the reference again, page number?
Sorry, yes, it starts at 2316, and it's paragraphs 147 and 148. 148 is where the court makes it clear, unsurprisingly, that it will take account of the UN Convention on the Rights of the Child.
Is this what you've been referring to previously as the Paraguayan?
Yes, that is. Yes, sorry. I couldn't remember the name of the party who'd brought the litigation against Paraguay. 162 is where the court talks about how the standard regarding degrading treatment in the case of a child is higher. 209 to 212 is where the court deals in particular with the impact of Article 19 on fair trials. Again, it refers to the UN Convention. It there refers to the need for discretion and the need to ensure that measures are appropriate and proportionate. And it says that the reason for that is child's vulnerability. And 231 is where the court talks about... Sorry, page... Sorry, it's paragraph 231. I'm sorry, I haven't followed through the page number, sorry. It's the same judgment. At 231 is where the court talks about the need for the liberty, any deprivation of liberty to be for the shortest period, and it refers again to the UN Convention. And so one sees the cross-fertilisation. The other source of that, which is the Committee on the Rights of the Child, which in our submission one can legitimately refer to, not least because of the references from the Inter-American Court. The General Committee comment that I was referring to, which deals with the specific issue, is at the relevant passages at page 2703, and Paris 78 is where the Committee on the Rights of the Child deals with minimum sentences. And as I say, that we would submit is legitimate to refer to for at least two reasons. One, because unsurprisingly, the Inter-American Court regards it as relevant when interpreting Article 19. And secondly, because Jamaica has ratified the UN Convention, indeed it's enacted legislation intended to reflect the UN Convention. And of course Article 3, as I already indicated, as was made clear by Baroness Hale in ZH, Article 3 of the UN Convention is now reflected in large numbers, a significant number of international instruments, demonstrating its widespread adoption, basically. And all of this, to a large extent, comes from that. So with all of that in mind, I come back to the basic point that in our submission, the current regime, because of the fact that it prevents account being taken of the individual's welfare considerations, because it may result in a sentence that is above the minimum required, taking account of things like culpability. That violates both the rights of the child under the Charter and the provisions on inhuman and degrading treatment. And the inhuman and degrading treatment point, at the risk of repeating myself, is violated because the sentence is disproportionate, because relevant material is just simply not taken into account. That, I think, covers everything. Well, obviously, there are things I would have gone to if I had time, but I think, given the time, that probably covers everything. But do you mind if I just turn around and check with those who they'll be happy? That, I think, covers everything.
Can you just summarise for me the ways in which you bring these international norms to which Jamaica has ratified down into the content of the Constitution, and particularly 13.3k. So I understand your reference to Boyce when it talks about measures of protection. That language reflects Article 19, and this is how Article 19 has been fleshed out in international instruments and the general comments, and cross-referring to the UN's CRC. Are there other ways in which you say that those norms on the international sphere are brought down into the domestic sphere as to the interpretation of the Charter, or is that's
probably the key points? Yes. But I would just add a couple of points in relation to that, which are to some extent in our written case, I think. The second point I would make, which is sort of a Boyce point, which is, in any event, even if in one sense you don't have the primary point, which is the presumption, one of the things that Boyce makes clear is that when you've got a generally worded provision, and there's no doubt that the provision in issue is generally worded, one of the things that judge has to do is look at what the standards of a just society are. And of course, if you have treaty provisions that are as widely accepted as, for example, the UN Convention is, that's a pretty clear guide as to what a just society requires. So that's potentially the second. It's not just a sort of presumption of interpretation. It's about looking at
presumption of interpretation that you interpret it to comply with international obligations.
It's also about this sort of quite difficult task for a judge, which is how does a judge work out what the standards of a just society are, and the treaty provisions, particularly where they've basically been accepted by the state, are a guide to that. The third point, which we definitely touch on our statement of case, but it shouldn't be lost sight of, is of course, for example, the American Convention, there is a right of Jamaican citizens to apply to the Inter-American Commission. And what the Charter clearly is intended to do is give people a mechanism for enforcing rights domestically for all sorts of good reasons. And in those circumstances as well, in terms of interpretation, what might be said to be the mirror principle, that's how it's been described in the Human Rights Act, potentially comes into play. It's important that you interpret it in a way that, as far as possible, is consistent, because otherwise the individual is required to apply to the Inter-American Commission.
Thank you very much.
Thank you.
Very helpful.
Thank you. Thank you.
Thank you, Mr. Savvy. Mr. Knox.
My Lords, I have three submissions, if I can summarise them. First, as held by the Court of Appeal, the sentence of 15 years imposed upon the appellant for wounding with intent to cause grievous bodily harm was not grossly disproportionate to the offence he committed, and therefore it did not amount to, I quote, inhuman or degrading punishment or other treatment, contrary to section 13.2.0 and section 13.6 of the Charter. Secondly, the Court of Appeal, in coming to this conclusion, did not fail to take into account the appellant's constitutional rights under section 13.3k.1 of the Charter or otherwise. And then third, even if, in some cases, the minimum sentence required by section 20, subsection 2 of the Offences Against the Person Act could lead to the imposition of a grossly disproportionate sentence, that is not a reason for striking down that provision on the basis that it is unconstitutional. In those cases where it does lead to such a result, then the 15-year minimum requirement should be read down to be a recommendation for 15 years, but save in such cases, the 15-year requirement must be given effect. And that's what I say is that in very broad outline. Just dealing with the structure, I'm going to look at, take you to one or two points on the facts, then go to the Court of Appeal's judgment. I then propose just to go through some of the local legislation, which I submit is absolutely fundamental and starts by looking at the local legislation. And then I will deal with the three main questions which I identify in our case. The first is, to what extent can international treaties assist in the interpretation of a constitution? And the second question is, was there a breach of the Constitution because the sentence imposed by the Court of Appeal was inhuman and degrading punishment? And then the third question, was there a breach by virtue of the failure to comply with section 13.3k? My Lords, my Lady, just on the facts, I just want to emphasise points which I'm sure you're well aware of, but I do submit as important from the State's point of view. This offence was not only very serious, but has caused great problems. It is exactly this type of offence which has caused great problems in in Jamaica. Forgive me. And my Lords, my Lady, you'll see at page 56 of the electronic bundle, you'll see the appellant's counsel. You see what he has had to say about it, which I submit puts the point rather well. Page 56, line 6. begins, line 6, Mr. Sandcroft, in his plea in mitigation, my Lord, the crime of illegal possession of firearms and ammunition and wounding with intent are serious charges, my Lord, and they are, in fact, they go beyond being serious. They're heinous charges, that's not saying one thing, ones which claim the society of Jamaica, and my Lord, they have had a ruinous and damaging effect on this country. Now, maybe one might say it's a plea of mitigation, perhaps you try to get over as well, you try to sort of soften the ground a bit, but even so, that is the background to the 15-year requirement on any footing, and also the background to the provision which you'll see in the Child Care Protection Act, which exempts this offence from the usual rule that which requires crimes to be tried in the Children's Court. But there's a really serious problem here. So all my learned friends' points are well made so far as the rights of the child go, but we are dealing with a very big wind going the other way, and I submit that is fundamental. The judge himself, I don't need to take you this at 62 to 63, says...
Just to understand that submission, are you saying that because of this, it justifies the imposition of an unjust sentence on a child?
Certainly not.
Right.
No.
Well, I mean, Section 42K appears to contemplate that minimum sentences may result in unjust sentences.
Yes.
Because they're manifestly excessive, not because they're grossly disproportionate.
Indeed.
Then I ask the question again, I mean, are you suggesting that a sentence which is unjust and manifestly excessive can be imposed upon a child which is not grossly disproportionate?
It may be the case. I mean, it might be a wafer-thin distinction, but I wouldn't want to say that the two always go hand in hand.
Okay.
It does appear, just on that point, it does appear, although one can't be sure, that the draftsman appears to be accepting that manifestly excessive is a ground which effectively means you can, as long as the judge accepts it's manifestly excessive, you can go to the Court of Appeal and see if the Court of Appeal, single Court of Appeal judge agrees with you. There is no provision, obviously, in the 2015 Act for about grossly disproportionate. My lords, my lady, whether, of course, the draftsman even contemplated that that might be the case, one doesn't know. But just so you know, my position is this. Let us say it was just grossly disproportionate. It wasn't a question of manifestly excessive. Then in those circumstances, my lords, my lady, I would accept that the judge would have to say, I don't think I can even pass this sentence in the first place and require you to go to the Court of Appeal, because then he'd be doing something which is forbidden by the Constitution. I mean, if you heard proper argument...
You've got it the wrong way round.
Yes.
It's, as I understood it, although one of the first questions we asked is, what is the test that's applied in an ordinary thing? Assuming that that's manifestly excessive, then it seems that if grossly disproportionate is the test for it being inhuman and degrading treatment, that is something further away from the norm than the manifestly excessive. So something can be manifestly excessive without meeting the threshold of being grossly disproportionate, but anything that's grossly disproportionate automatically must be manifestly excessive.
I accept that. You are then left with the problem, which I dare say the legislature didn't think about. What if the judge is presented with a position where he thinks 15 years is not only manifestly excessive, but he thinks it's just grossly disproportionate? Now, one way of construing the 2015 provisions is, well, the judge must still pass the sentence and then give permission, or rather give a certificate, and then the whole matter goes off to the Court of Appeal. That's one way of looking at the 2015 legislation. The other way of looking at it is simply the judge should simply say to himself, well, this is not just manifestly excessive, this is even worse than that, and therefore I simply am forbidden by the Constitution from passing the sentence. That's another way of looking at it.
And that's the way we prefer.
My lords, my lords, my lady, I would accept that would appear to be a more principled way of looking at it.
The Constitution is supreme law.
Yeah, exactly.
Yeah.
That's why I say that. Because it may, my lords, I'm not specifically here to argue the point. The difficulty is the Court of Appeal below hasn't heard argument on what you might call the distinction between manifestly excessive in the 2015 legislation and grossly disproportionate. And therefore, my lords, my lady, I submit it might be rather dangerous for your lordships, without having the benefit of the Court of Appeal's view on that matter, to express a final view on it. But if you ask me what would appear to be a more principled view, then it's what I've just put forward. There may be contrary arguments, of course. It might be said, given that there is the power to send the matter up to the judge of the Court of Appeal, therefore the court might be said, well, I'm not actually imposing an unconstitutional sentence because I'm putting in a caveat which allows the matter to go to the single judge of the Court of Appeal.
But in our case, obviously, the appellant was sentenced before the 2015 Act.
Oh, exactly.
And he didn't avail himself of the transitional provisions.
Yep.
So we're operating in a pre-2015 Act world.
Yes.
And in that world, the 15-year sentence couldn't be manifestly excessive because it's prescribed by law.
Because it was
a prescribed minimum.
Yes.
But it could still be grossly disproportionate.
It could be, exactly.
Yes.
Yeah.
Yes, my lord.
I think the logic of your position would be, in a pre-2015 Act world, the Constitution still applies and is supreme law, and would prevent a judge from imposing a minimum sentence if the judge considered that to do so would be grossly disproportionate.
Exactly. And theoretically, the judge might, forget all about the 2015 legislation, theoretically the judge might have said to himself, well, I think it's manifestly excessive, actually, but I don't think it's grossly disproportionate. And then he would have said, well, I've got no alternative now but to put a 15-year sentence on. Now, of course, no one is saying that actually is what the judge thought at the time at all. And I think I'm probably right in saying the Court of Appeal itself didn't, although it mentioned the 2015 legislation, it didn't go into this question of what is the interrelationship between the 2015 legislation and the Constitution. And my lords, my lady, I suggest that it might be risky for your lordships, my ladyship, to come to a concluded view on exactly what the interrelationship is when you simply haven't heard argument. Well, you have no views from the courts below as to quite how this should be.
You're putting forward, and everyone appears to agree, that the test is grossly disproportionate. And then the next question is, what does that mean in comparison to manifestly excessive? And are you able to tell us?
Outside the range, well, manifestly excessive is outside the range, which is normally recommended for this. Grossly disproportionate, I think all I can do is rather feebly say, well, it's something which is even worse than outside the range. It's got the word gross in front of it. Well, grossly disproportionate.
I wonder if that's necessarily right, because if on your analysis, as I understand it, the process involved in the sentencing of a child is that you look at all the relevant factors and you come to a view about what the sentence should be, and that view may well be, in a very serious case, that a sentence of 15 years or more is appropriate. But for various reasons, particularly where you got an immediate plea and there was some background in relation to the child, you might end up concluding on the approach that you take that the appropriate sentence, applying the other guidelines apart from the minimum sentence, will say it are about 10 years,
yes,
or 11 years. Now, if that's not grossly disproportionate, it's certainly manifestly excessive.
Yes.
And despite the fact that it would, against ordinary guidelines, be manifestly excessive, I just want to be clear that you say that because of the minimum sentencing provision, it becomes not manifestly excessive. Is that right?
Yes. My lord, that would appear, although they don't put it this way, in a sense that's the logic of the Court of Appeal's reasoning. Yeah. They essentially say, well, it would have been 12 years. We would have come to a figure of 12 years or so for the shooting, wounding with intent. That would have been the figure.
But they said it wasn't manifestly excessive either. Remember?
Yes, they did. Well,
that's right. So what I'm putting to you is a case where you say, applying the guidelines, it is actually manifestly excessive in the usual way, taking everything into account. But my understanding is that if you do that exercise and take everything into account and come to the view that a sentence of 11 years or something of that kind was appropriate, and recognise that in the ordinary course that would be manifestly excessive, that the minimum sentence provisions, you say, automatically transfers that to not being manifestly excessive because of the statutory provision.
Yes.
Is that right?
Yes. it allows some leeway, if I can put it that way.
So I was just going to say, I mean, one way to reason it in, let's take it as a pre-2015 Act world, the question of manifest excessiveness doesn't even arise. I mean, essentially for the reason that my Lord Reid was indicating, it's a sentence prescribed by law.
Yes.
It's not open to a court to say, well, do I regard this sentence as manifestly excessive? There is no legal rubric which allows the court to ask that question. There is a legal rubric that allows the court to ask a different question, which is, well, strictly, would it be an inhumane, degrading punishment, which is then, according to the case law, translated into grossly disproportionate. So before you get the 2015 Act, the question of manifest excessiveness seems to me not to arise. It does arise post-2015, but then that's because the statute has invited both the trial judge as the trigger mechanism and the Court of Appeal judge to do a mental exercise which wasn't open to them before.
Exactly. My Lord, that's exactly the position. I accept that. My Lord, I mean, if you are, I think the question that's being asked is, well, what in real life is the difference between manifestly excessive on the one hand and grossly disproportionate on the other? How does one tell the difference? I suppose one might just say, well, the difference partly comes down to the word grossly. I mean, you might say it's a vituperative epithet, but it is grossly, it is just almost inexplicably disproportionate. It grows completely out of proportion.
But even on that, one ought not to forget the starting point, which is the actual rubric in the Constitution is inhuman or degrading treatment.
That's merely a translation of the original words. Yes, I accept that. And so that would be the ultimate question, although often is answered by reference to the gross disproportionate test.
So you accept, I think, in your written case, that the exercise that the Court of Appeal carried out here of asking themselves, is this a grossly disproportionate sentence, was a legitimate exercise.
Yes.
But it would not have been legitimate for them to just treat this as an ordinary appeal and decide whether the sentence was manifestly excessive.
No, if you leave the 2015 Act out.
Yes, yeah.
And I say they did the right thing. No doubt on an alternative basis, but they did consider whether the sentence was in any event grossly disproportionate. Their primary finding, of course, was that you didn't even get there because Section 20, subsection 2 was saved law. That was their primary finding. But then they go on to say, in any event, it's not grossly disproportionate. And that is the part of their judgment which I obviously adopt. Yeah. And say they got it right.
But they got it wrong in saying that also wasn't manifestly excessive. Because they're not allowed to say that, because there's a minimum.
Oh, I see. In that sense, yes. At that point, if in the pre-2015 world, they as were made a finding that was irrelevant.
Well, yeah, entirely theoretical.
And the prescribed by law accompany of law, because you then get into the inhuman treatment provision.
Yes.
So it's not manifestly excessive because it's prescribed by law. Then if you get an outrageous law that imposes an outrageous sentence, then you're straight into inhuman.
Yes. It doesn't qualify as a law in the first place.
Yeah.
I'd accept that. Just if I just may go back to just one or two points on the offences. It is worth emphasising the point that at the time of the offence, the appellant was 16, and that's on the 28th of August 2012, and he was 17 by the time of trial and sentence. And I do submit that's an important background to this case, because I fully understand my learned friend's point that obviously, if one was talking about, let's say, a 12-year-old or 14-year-old, what you might call the child factor, the child welfare factor, obviously is going to play more strongly than in the case of someone who's 60 or 17. It doesn't follow from what I say that, therefore, you ignore the fact that this person is a child, but the question of how much weight one gives to the child welfare and the best interests of the child, in my submission, must vary to an extent with the child's age.
Well, if the child was under 14, as I understand it, they would have been tried in the children's court.
They would have to be tried in the children's court.
And would the maximum sentence still be 25 years in the children's court?
Well, as I read the Act, yes, but I have to admit I was reading again last night, and I did struggle with some of how it all interrelates. But that would appear to be the case, yes.
Can I just ask, we've all taken it for granted that the age of majority is 18. I hope somebody's actually checked that.
Yes, I have. I think it is 18, and it's. I think there's a notion. Perhaps I can go. Shall I just go to the Act just so you can see what it says? I think there's a young person and there's a juvenile and a child, and you can find the Act. I think that I'm talking about the Child Care Protection Act at page 364. And section 2 is the definition section. And you'll see adult is someone who's attained 18. Child means person under 18. And then over the page, juvenile, I'd rather assume there's a definition of juvenile.
It was separately identified, but I maybe missed it.
Sorry?
I didn't think it was separately
definitely identified in previous statutes.
But I may have missed it.
It may be they simply don't bother to do it because they use the phrase under 14 and so forth in the relevant parts. But anyway, it's 18, my lord.
And is there any definition in the Constitution?
No, not as far as I'm aware. I don't think we did look to see if there's minor or child or anything. We couldn't see anything in that. And there is also a provision, I think it's the age of 10 from that recollection, where you are dolly in capax, you simply can't be 12. It's maybe it's 12, yes.
So in the absence of a definition in the Constitution, do we act on the assumption that the word has the meaning it has in the general law?
Yes. Just going back to the facts, it is important to remember that, according to the person who was attacked, the gun was pointed at, and I quote now, directly in front of me, about an arm's length away. And this is a very serious attack. It's not just something, it was just bad luck, so to speak. That's at E21:11 to 22:14. And then the appellant shot him while he was still only an arm's length away. So it's at very close quarters, and causing him to suffer a piercing feeling in his chest and so forth, as he was preparing to run away. That's at E25, line 2 to 26, line 5. And then there were further gunshot explosions, that's E27 to 28. And then the appellant and his cousin picked up spent shells from 2 more shots that had been fired. It's E28:11 to 29:1. So there's an element of, as we're deliberately covering their tracks. And the victim, the person attacked, suffered a back wound, and he spent a week in hospital. Our learned friend has referred to the social inquiry report. Might just be worth noting that according to, it's at E51 last paragraph to E52 first paragraph, he had become, perhaps not very surprising, very fearful since the incident. Went by taxi rather than public transport. His business, he'd lost lots of his clients because his phone had been stolen, and he was also frightened because he was living next to the community from where the appellant came from, and he was worried about reprisals, and it had affected his academic performance. And as the report concluded, he could have died as a result of the attack, and he was obviously been badly affected by it. My lords, those are obviously matters which are relevant on the question of sentence. You do look at the effect upon the victim. And this was
all those matters, but I mean, the best guide we have really to an appropriate sentence, if one disregarded the statutory minimum, is the reasoning of the Jamaican Court of Appeal.
Yes.
And they take account of all these aggravating factors, as well as the mitigating factors to do with his youth and his personal circumstances, and they conclude that a sentence of 17 years would ordinarily have been appropriate, and then they discount by 20% to take account of the plea of guilty after the complainant had given evidence, and they also discount to take account of the time served in custody, and that brings them down to 12 years and 10 months. And it's in light of that assessment that they conclude that the minimum of 15 years was not grossly disproportionate.
Yes.
And they, I dare say they may also have had regard to the concurrent sentences of 9 years and, what was it, 10 years and 4 months for the other offences.
And my lords, my lady, I submit the sentences passed for the other offences are significant, because 9 years for illegal possession of a firearm, 10 years, 4 months for robbery with aggravation. Well, it does rather suggest that the 15-year sentence for the wounding with intent is not completely out of line, as indeed the Court of Appeal said, not completely out of line with what one would expect. And I emphasise no attack is made on the Court of Appeal's sentencing in relation to the other two sentences. It's not suggested there that there was a failure to take into account Section 3K of the Constitution. And I submit that of itself as an indicator that the 15-year imposed for the wounding with intent charge cannot be said to be grossly disproportionate. Now,
they're all from the same incident, so...
All the same incident, yes. I don't think I need, in those circumstances, to take you to the Court of Appeal's judgment. I just want to emphasise one point, and that's 116 of the bundle, paragraph 101. So I make this point to meet the proposition that the Court of Appeal didn't take into account what you might call the best interests of the child's requirements. And so at the foot of page 116, the next course would be to choose a starting point within that range. At this point, I should say, dealing with the wounding with intent charge, i.e. the one we are considering here. And in Carey and Scarlett, Mr. Justice of Appeal Brooks said that on conviction for wounding with intent using a firearm, a sentence of 15 years was, quote, at the low end, a sentence of 20 years at the high end of the normal range. This is a sentence I want to emphasise. In this case, we would choose a starting point of 15 years, since TM was a child at the time he committed the offence, and having regard to the provisions of the CCPA. And that, in my submission, is plainly a reference back to the best interest provisions, which they have previously discussed, the CCPA. So they've got well in mind the CCPA, the Child Care Protection Act provision.
It also means there's a double discounting.
Yes, there is, because they come back to it later. Well, it looks as if that's what they did, but in any event, they've certainly given credit for the fact that the appellant was a child. And my learned friend might say, oh, but they didn't go through necessarily all the welfare points that could be made on his behalf. But in my submission, that's not necessarily a sentencing exercise, as long as it's apparent that a sufficient regard has been paid to the fact that the appellant is 16 years at the time of the offence and so forth, or they've taken a starting point of 15 years, they've gone back 5 years. In my submission, that's sufficient. It's implicit in that. I mean, there's no reason for taking into account the fact he's a child and then reducing the starting point, unless, of course, you are taking into account the fact that it is relevant. There are relevant considerations, and they must be, effectively, those sort of considerations provided for by the Child Care Protection Act.
It's an unusual way, actually, to fix a starting point for an offence, because ordinarily you fix the starting point by reference to the actual offence itself.
Yes.
And for instance, how serious the injuries were that were sustained and how long-lasting they were. And then you are very careful when you add in the aggravating factors in relation to the offence that you don't double count those factors that lead you to the starting point.
Yes.
I haven't come across before a starting point being fixed by reference to a mitigating factor.
Well, my lord, there it is. I mean, in one sense, it might be said, I could say on my behalf, as it were, well, that just shows they are deliberately, so to speak, saying he's a child, therefore let's start off with a lower starting figure. And they do appear to give what you might call a double discount. If you read paragraphs 101 and 102 together. But I just make this point on what you might call my learned friend's case in relation to failure to take into account the Section 33K considerations. I submit you cannot properly say the Court of Appeal has failed to take into account the Section 33K considerations. I think they conclude at 107 13 years, 6 months would have been imposed, but they reduced that to 12 years, 10 months, taking into account the time in custody before trial. That's paragraph 107. Now, I submit that's quite significant. This one there is looking at 12 years, 10 months as the sentence they would have given, taking into account time spent in custody. And so I submit it's perfectly rational to say, well, that being the case, it is not disproportionate to order a sentence of 15 years. In my submission, that reasoning is difficult to attack.
Well, yeah, sorry, just picking up on the language, not grossly disproportionate. I mean, that is the question they posed themselves in paragraph 108, and as I understand it, it's basically common ground. That's the relevant test. So they posed themselves the relevant constitutional question,
Yes.
and given an answer against the backdrop of the reasoning that you've highlighted.
And my lord, as you say, I mean, they do also go on to say, nor was it manifestly burdensome and excessive. But you can cut that. That's odious for my purposes.
But what they were expressing was a view that in the absence of a minimum sentence, 15 years would not have been manifestly excessive.
Yes.
Yeah.
I rather read that as, since they've been through the way the 2015 Act works, that notwithstanding that it didn't arise on this case, they were just giving an indication that, in their view, even if it had applied, one wouldn't have been in that territory either, which is a separate question.
This sentence was before the 2015 Act.
Yes, yeah, no, I appreciate that. I'm just saying, why do they even bother talking about that? The best I could do in understanding it was because they've been through the mechanisms under that Act. Perhaps they thought it was worthwhile passing that comment.
Well, one can understand why, actually.
But I respectfully agree.
If they had thought differently, they might say, well, you might want to make an application, you might be a bit late and so forth. But they've effectively closed off both avenues of attack. One of which was the only real avenue of attack. The other was a theoretical avenue, but they've closed them both off.
Again, I rather read it as sort of, well, this isn't quite the right way to put it, of putting the appellant's mind at rest, that even if he'd been in time to operate the mechanism under the 2015 Act, it wouldn't have done him any good. But that's speculation. I don't want to take up time.
Yes, but the implication of the last few words of 108 is that if this had been an ordinary sentence appeal, it would have been rejected.
Yes. Because it wasn't that far off.
Yeah.
But my lord's one speculating, and I don't specifically rely on.
And so if the approach that Lady Rose was putting to you earlier of grossly disproportionate being a subset of manifestly excessive, if that's correct, then a fortiori that hurdle wouldn't have been passed either.
In relation to an ordinary appeal sentence, a sentence against appeal, there are two grounds. One is wrong in principle, and the second is manifestly excessive.
Yes.
And wrong in principle would be to leave out of account the time spent in custody, the discount for a guilty plea, and mitigation due to childhood. So I still struggle with an ordinary sentence appeal as to whether or not 12 years, 10 months would not be wrong in principle.
It would be wrong in principle.
Yes.
7 months.
Sorry, 12 years and 10 months would be the correct sentence, and the 15 years would be wrong in principle, if it was an ordinary sentence.
Yes. Well, we adopt that. We say if that was the only difference, then it would not have been. Let's say you hadn't had a minimum sentence regime at all, and the matter had come up simply on a 15-year sentence. The Court of Appeal, in my situation, would be entitled to say, well, we might have made it 12 years, 10 months, but the judge said 15 years, and we're not going to interfere with that.
Well, I wonder if that's so, because it would be, the point that I'm making is that it is not only the test is not only. That's why I was interested in what the test is in Jamaica and what the statutory provision is. The test is not only manifestly excessive, but wrong in principle.
Yes.
And the principle here would be that you would have to take into account the time spent on remand. And also you'd have to give a discount for the guilty plea.
Yes.
And so it would be potentially wrong in principle.
Well, the 12 years, 10 months does give credit for the...
I know, but 15 years wouldn't.
Yes.
So an ordinary sentence appeal would be successful.
Well, if the, obviously, there's a difference in the time, but in my submission, this would have been a sentence the court could have upheld on the footing that there was no error in principle. Let's say the judge had properly come to review of 15 years. Court of Appeal could have said to itself, well, 12 years, 10 months is not that different from 15 years. We don't think, we would have said 12 years, 10 months with a discount for the custody in time. Time in custody. Therefore, there's nothing that the judge has failed properly to take into account in coming to his view.
No, I don't think that can be right. I agree with Lord Stevens that if the mistake was to not give a discount to the guilty plea and not to take into account, then you knock those off on appeal because it may not be manifestly excessive, but if you're doing the time, it is quite a long time extra, and you're entitled not to serve that time.
I accept that. So I misunderstood the question. Certainly, if there is some error in what should I call it, he failed to take into account the following factors, or he wrongly took into account the following factors, then in those circumstances I would accept that one could challenge the sentence.
I'm afraid I've lost track of the argument here. Is the proposition that the judge actually erred in the world we're in with a minimum sentence, because notwithstanding the statutory minimum, he ought to have given a discount for a guilty plea, and he ought to have backdated the sentence or reduced it by the time served on remand? Or are we in a parallel universe where the minimum sentence doesn't exist and we're contemplating a sentence imposed on ordinary sentencing principles?
But my lord, I forgive me, it's probably my fault. I was in the parallel universe, not in real life.
Right. We're all in the parallel universe.
In that parallel universe, if there has been a mistake, even if it only knocks off 10 months,
that's that.
Then you get knocked off 10 months. You don't then apply an additional test of whether it's manifestly.
No. You just say the judge didn't take into account X, therefore 10 months off, or whatever. I accept that.
But the Court of Appeal must have been in the parallel universe, or must have travelled into the parallel universe.
Well, they were travelling in the parallel universe at this point, but they make their position plain.
And yet their conclusion that it wasn't manifestly excessive appears to be wrong then. If the position is that the 15-year sentence was one that didn't allow for the period spent in custody.
Well, if I may say, with respect, I'm not sure that the Court of Appeal was in the parallel universe in paragraph 108.
No, I mean at the very end of it travelled from one to the other.
That's why I raised the point that it's unclear exactly what they're doing, but they could have been passing comment on if this had been a post-2015 Act case, because then the only test is manifestly excessive. That's the trigger for coming up. I.e., not a pure parallel universe case where it's wrong in principle or manifestly excessive.
Yes, well, I think we'd better leave.
Yes. Can I for the moment leave them?
Can I just check? Have we positively established that there is a test of wrong in principle in Jamaica?
My lord, I have always assumed there is, but I do not know. I cannot tell you.
No, I mean there isn't north of the border, for example. We used to, even if there'd been a failure to knock off time for the period spent on remand, for example, we would still refuse the appeal if the sentence wasn't excessive.
Yes.
Whereas the approach in Northern Ireland and England is different. And Jamaica probably follows England, but I just wouldn't take it for granted.
My lord, maybe it's something we can ascertain overnight.
I would actually like to see the statutory provision that gives power to the Court of Appeal and the principles that are to be applied by the Court of Appeal in Jamaica.
We shall get that. I'd like, if I may now, just to go to the relevant legislation and just run through the position chronologically. In 1953, your ladyship will be aware from other cases, the United Kingdom exceeded, or rather gave notice that it was exceeding to the European Convention on Human Rights under Article 63 and that extended to Jamaica. So from that point on, Jamaica was, in that respect, subject to the ECHR. Then in 1962, you have the Jamaican Constitution, passed by an ordering council, and it does appear that some of its fundamental rights provisions were modelled on those in the ECHR. In particular, can I ask you to look again at section 17 at 279. This seems to be, albeit the words are put in a slightly different order, almost exactly the same as you find in the ECHR. Section 17.1. No person shall be subjected to torture or to human or degrading punishment or other treatment. And I think if you go to page 464, you will see the ECHR provision, Article 3. No one shall be subjected to torture or inhuman or degrading treatment or punishment. So it is virtually identical, materially identical. The words are in a slightly different order. That's it. And I do submit, therefore, that the decisions of the ECHR on how to approach Article 3 may be of some assistance in deciding how one should approach Section 17 of the Constitution and its successor in the Charter. At the time, there was a Juveniles Act in force, which had been passed in 1951, which you can see at 393. Bundle. Well, 389 is where it begins, and you can see, if I can just go for the moment to page, I think it's 393, you'll see various definitions given. In particular, child means a person under the age of 14, and then 394, juvenile, means under the age of 17, and a young person is someone who is between 14 and 17. And then over the page at 395, you'll see a provision which was amended. I'll say what the previous version was in a moment, which is amended in 1995.
So does that leave a gap for people who are under 18 but above 17?
As I understand it, if you are under 17, there are specific provisions which deal with the position if you're under under 18, but there doesn't appear to be any specific definition of what an 18-year-old is. But there are specific provisions. For instance, at 395, you'll see section 29.1 provides for the position in relation to someone who is under 18. But on the whole, it seems that the Act applies up to the age of 17 rather than up to the age of 18, subject to specific provisions otherwise. But you'll see section 29.1 talks about the sentence of death not being passed on anyone who was under the age of 18 years when the offence was committed. And 2, a juvenile shall not be sentenced to imprisonment, whether with or without hard labour, for any offence, or be committed to an adult correctional centre in default of payment of any fine, damages or costs. You'll see down the left-hand column that there was an amendment. This is the result of an amendment made in 1985. Previously, and I can take you to this if you like, there had been prison for the word adult correctional centre. So in 1962, this would have read, a juvenile shall not be sentenced to imprisonment and so forth for any offence or committed to a prison in default of payment. And then subsection 3, you'll see where a young person is convicted of an offence in the 3rd schedule, and that includes the offences we're talking about here, such as section 20. And the court is of opinion that none of the other methods in which the case may be legally dealt with is suitable, the court may sentence the offender to be detained for such period as may be specified in the sentence. Where such a sentence has been passed, the young person shall, during that period, notwithstanding anything in the other provisions of this Act, be liable to be detained in such place, including an adult correctional centre, and on such conditions as the Minister may direct. And again, in 1951, and as at 1962, adult correctional centre read prison. And then you'll see a provision...
So you read 29.2 as really just dealing with circumstances in which there's been a failure to pay any fine, damages or costs.
It looks like that, yes.
It's not just a blanket ban on sentencing a juvenile to imprisonment.
No, because otherwise the subsection 3 would have no content. And subsection 4 gives the Governor-General a power to release on licence on such terms as he thinks fit. And then the third schedule, which you'll see referred to in section 29.3, where a young person is convicted of an offence specified in the third schedule and so forth. If you turn to 397, you'll see the third schedule. And that has an offence under various OAPA provisions, including section 20. So in other words, it was always the case, if I can put it this way, that if you were convicted of an offence under section 20, then you could be detained in a prison, or at least since 1985, in an adult correctional centre. That was the scheme of things. In 1991, Jamaica ratified the United Nations Convention on the Rights of the Child, and that you can see described in general terms in the Court of Appeal's judgment, but it provides for a wide range of rights for the child. For instance, education, right to freedom of expression, and so on. And I would like to take you, if I may, to page 478. Article 3. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration. And then Article 6.2, I'm just giving examples. State parties should ensure to the maximum extent possible the survival and the development of the child. You can see that's obviously relevant perhaps to sentencing as well. And then Article 37, you have at page 479, near the foot of the page, states parties should ensure that no child shall be subjected to torture or other cruel, inhuman or degrading treatment, punishment, no capital punishment, and so forth, or life imprisonment on someone below the age of 18. No child should be deprived of his or her liberty unlawfully or arbitrarily. The arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time. Then C, every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner which takes into account the needs of persons of his or her age. And then a tail end saying you mustn't put them in prison with adults. Now, in 2004, that's 13 years later, the Child Care and Protection Act was passed. And if you turn up the Court of Appeal judgment at page 101, paragraph 73, the version we have in the bundle doesn't include this, but we can take it from the Court of Appeal's judgment. 70, page 101. The Jamaican Parliament has for some time recognised the need to treat children differently from adults when they come into conflict with the law. This acknowledgement can be seen in the passage of the Juveniles Act, which has since been repealed by the CCPA in 2004. And this is the point I want to emphasise. The Memorandum of Objects and Reasons for that Act stated that in May 1991, Jamaica had ratified the CRC, that's the treaty I showed you, and therefore took a decision, quote, to enact legislation to combine and reinforce existing child protection legislation with new legislative provisions to protect children from abuse. The Child Care Protection Bill sought to enable Jamaica to fulfil its CRC treaty obligations and to fully incorporate them into national legislation. And they go on over the next few pages to discuss the CRC, I think I'm right in saying, until about paragraph 83 on page 107. So you've got there for your future note an explanation of what the CRC does. I just want to show you one or two provisions. In broad terms, what it does is it does actually replicate the treaty which I showed you. But it obviously carves out certain exceptions, in particular in relation to offences such as those under the Offences Against the Person Act. First of all, if I can ask you please to go to page 366. Begins at 364. But at 366 you have the definitions. And you'll see here it's provided that adult means a person who has attained the age of 18 years. Child means a person under the age of 18 years. There's a provision for children's courts, immediately or almost immediately below. And then over the page, there is a provision for subsection 2, so I particularly want to draw your attention to. Where there is a reference in this Act to the best interests of a child, the factors to be taken into account in determining the child's best interest shall include A, the safety of the child, B, the child's physical and emotional needs and level of development, C, the importance of continuity in the child's care, D, the quality of the relationship the child has with the parent or other person, E, the child's religious and spiritual views, then educational requirements, and then that he's given sufficient opportunity to express his views, and so on. So that is what the best interests of the child are directed towards. It's not really specifically directed towards anything to do with the criminal system. It's a much more, what I call, proactive social requirement. And then, subsection 3, this Act shall be interpreted and administered so that the best interest of the child is the paramount consideration, and in accordance with the following principles. And you'll see what those principles are. Protection from abuse, they're kept in the family, support, if the family can't, well, if available support services, you should keep them in the family, and so forth. There's not specifically, I just want to draw your attention to this, it's not specifically tied to anything to do with the criminal system. It's more making sure that generally children are able to be brought up in a normal environment with educational advantages and such things as that. And then, section 3, page 369, the objects of this Act are to promote the best interest, safety and well-being of children. And if I may just go back to what the Court of Appeal said, you'll recall I said the Court of Appeal talked about the CCPR, the CCPA provisions. This is the sort of thing they're talking about. You've got to look at the best interest of the child. And that's the object of the Act. There are a number of provisions which I don't need to take you to, but I would like to go, if I may, to part 4, which is at page 371 onwards. Section 63. It shall be conclusively presumed that no child under the age of 12 years can be guilty of an offence. And then there are various provisions for how the court is to deal with the child brought before it in section 64. And you'll see section 65, every court in dealing with the child who's brought before it, either as being in need of care or protection or as an offender or otherwise, shall have regard to the best interests of the child, and shall, if it deems necessary, take steps for removing the child from undesirable surroundings, and so on. Section 68 deals with the provision for bail. A court remanding or committing for trial who is not released on bail shall commit the trial to custody in a juvenile remand centre named in the commitment to be detained there, and so forth. And then I think it's section 69, I'm not quite sure where, it may not matter, there's provision for the minister to set up children's courts. My lords, I seem to have lost the reference to that, but I think 71.1. I can move over to section 71 on page 378. So 376. 376. The minister is to be responsible for setting up the children's courts. And the children's courts, broadly speaking, are to try all offences involved. That's the broad scheme of it. And only children's courts can hear summary offences. You then go to section 72, which explains in rather more detail what children's courts can and can't do. 72.1, the subject of the provisions of this section, no charge against a child and no application in relation to a child in need of care or protection shall be heard by any court of summary jurisdiction which is not a children's court. And then you have provision for what if there's an adult as well, in 72.2. And then dropping down to 72.5, where in the course of any proceedings before any court of summary jurisdiction other than the children's court it appears that the person to whom proceedings relate is a child, nothing in this section shall be construed as preventing that court, if it thinks fit, from proceeding with the hearing and determination of these proceedings. Then 6, this is the important provision, where a child A who has not attained the age of 14 years is charged with any offence, or B who has attained the age of 14 years is charged with any offence other than an offence specified in the 4th schedule, the charge shall, subject to any right of appeal provided by this or any other enactment, finally be disposed of by a children's court, or if the charge is heard before a court of summary jurisdiction that's not a children's court, by that court of summary jurisdiction, without provision without prejudice to section 75. So in other words, all charges, except those in the 4th schedule, are to be dealt with in the children's court. Now, we don't have the 4th schedule, I'm not quite sure what happened, but anyway, the 4th schedule is in the same terms as the Juveniles Act, which I've referred to before. So in other words, save for the sort of offences we're talking about here, everything has to be dealt with by the children's court. In subsection 7, where a child who has attained the age of 14 years is charged with an offence specified in the 4th schedule, proceedings for the child's committal to trial shall, subject to subsection 1, be heard in the children's court, and B, if on termination of those proceedings the court is satisfied that the child shall be committed for trial, the court shall so commit the child and shall bind such child over the record licence and so on. And then 74.380, where under the provisions of this Act a child is tried before any court which is not a children's court, then such court shall in relation to that child have all the powers of a children's court. And then 75.1, any court by or before which a child is found guilty of an offence other than murder may, if it thinks fit, remit the case to a children's court acting for the place where the offender was committed for trial, or if he was not committed for trial, to a children's court. And then subsection 2, where any such case is remitted, the offender shall be brought before a children's court accordingly, and the court may deal with him in any way it might have dealt with him if he had been tried and found guilty by that court. Now, I think it's been assumed on all sides that these provisions are overridden by the 15-year minimum term. That appears to have been the premise on which the courts below have operated. And my lord, that's the premise on which I operate now. Now, what I submit one gets out of all this is that there's a detailed attempt to put into effect the CRC, if I can call it that, in this Act, but they have deliberately not put in certain provisions. And in particular, in relation to the Section 20 offences and the like, the legislature has deliberately not included a provision, for instance, to the effect that imprisonment is to be is to be a matter of last resort. Quite the opposite. They have expressly provided that the children should, in certain circumstances, for certain types of crime, over the age of 14, be tried in the normal courts and sentenced accordingly.
So have they mentioned, is the last resort or shortest possible mentioned here in relation to children under 14, or is it just not?
I don't think it is even there, actually, no, not specific. I don't think if you typed in last resort and went through the Act, I don't think you get anything from that. So they've deliberately, in my submission, not put in certain provisions, and this I submit is where the case, I submit, that does require some, if I can put it this way, some thought. This is a case where there's an international treaty, where what has happened, which provides for A to Z, and what has happened is the legislature has provided for A to S and left out T to Z. Now, my submission is the legislature is perfectly entitled to do that, as long as the result does not, as long as someone's constitutional rights are not infringed as a result. In other words, the legislature has a margin of appreciation in deciding what provisions it can bring in. And as long as what it does doesn't fall outside that margin of appreciation, or as long as what it does doesn't result in an absolutely absurd law which infringes someone's rights, then in my submission, it's entitled to do what it did.
Well, the closest it gets to it in a sense is Section 3 of the Act. The objects of the Act are B, to recognise that, B2, the least restrictive or disruptive course of action that is available and appropriate in a particular case to help a child should be followed. One sees there, though, no further detail in relation to that in the criminal context and in within this section of the Act. It looks as though if this is dealing with matters other than the criminal matters which then come into play in Section 63, 4, 5 on.
Yes. You could read it as saying, well, it's sort of dealing with the criminal sense as well, but it's a funny way of putting it. It's more talking about, for instance, taking children away from their parents and that sort of thing.
Yeah, the position of children in the criminal justice system, I think, is dealt with in D, in the same section.
Yes. My Lord, I'm grateful, yes. It could be, yes. It would seem to come within that.
Well, those two things might go together.
Yes. But I accept it's not exactly clear what that means, but anyway, it's an indication. But what I would accept is, of course, what this Act is saying is that when it comes to sentencing, you should take into account the best interests of the child. And I can't get around that. But take into account, rather than give paramount force to, but you take into account what their interests are. And that will normally be, obviously, not to be sentenced for a long time, and to give them an opportunity to be rehabilitated and so forth. But as I've said, there's a sliding scale as far as that goes. It is different for the 12-year-old, as I say, than it is for the 17-year-old. But the reason I emphasise this Act is because I say the course, when you've got an Act like this, which has chosen a specific policy, and limited the incorporation of a treaty, it is wrong in principle then to say, well, never mind, you can, so to speak, nonetheless read the relevant provisions of the Constitution as being subject to, or that you should read them subject to or as influenced by those parts of the treaty which the legislature decided not to bring into effect. Now, if I can just anticipate a little, this, of course, is in 2004. But my first position chronologically is that in 2004 there was no inconsistency between the law in Jamaica as brought into effect by this Act and any international conventions. If there was an inconsistency, it was one which the Jamaican legislature was entitled to bring about. And the question, in one sense, comes down to this, which I will address later, but I just anticipate what the question is. What difference does it make that in 2011 you have a specific provision relating to children? Does that make all the difference? And my submission, I'm going to come to the argument later, in my submission, it does not make the difference. It's not the case that, so to speak, the other provisions of the CRC somehow got introduced in the back door by virtue of section 13.3k
so
of the Constitution.
You say this was an implementation of the CRC, even looking at Jamaica's treaty obligations on the international sphere. You say they have a margin of appreciation, so the way they implemented it was not in breach of those international obligations to which the state was.
Yes.
But then, even if it was, well, that doesn't sound in domestic law of itself, and also doesn't sound in domestic law by importing those additional bits into the into the 1962 Constitution, yes. And yes. Then into the Charter.
Exactly, my lady. That's the way we put our case. Now, in 2010, there is the amendment to the Offences Against the Person Act, which is at 362. Section 20 of the Principal Act is amended by deleting the word whosoever and substituting, therefore, the word subject to subsection 2, whosoever. Then we renumber section 2, and then inserting after subsection 1, a person who is convicted before a circuit court of A, shooting with intent to do grievous bodily harm, and so forth, or wounding with intent, comma, with use of a firearm, shall be liable to imprisonment for life or such other term not being less than 15 years as the court considers appropriate. Now, apparently, it's fairly obvious what this was to do with in the Court of Appeal's judgment. This, according to the Attorney General's submissions to the Court of Appeal, was introduced to tackle the high crime rate in the country and to reduce the threat to national security and public safety imposed by the increasing use of illegal firearms, and a number of other firearms acts were also amended at the same time. I don't have the reference to that, but I can provide it later. But that was the Attorney General explaining why, and in one sense it's obvious why they've done this. You wouldn't just introduce it for fun, but there's a very serious problem. And my lord, my lady, you'll have seen what the judge had to say and what was said by counsel. You then have in 2011, not long after this minimum sentence regime being introduced, the 2011 Charter, which is at 238. I would just like to take you to one or two points in the Charter at 238. Sir Dr. Morgan asked a question about what were the, so to speak, papers prepared for this and so forth. At 238 you have the answer. An act to amend the Constitution, I should say it's passed by a special majority, this act, because it's removing the previous similar provisions. And you will see, whereas a constitutional commission established by Parliament recommended, after wide public consultation and due deliberation, that Chapter 3 should be replaced by a new chapter which provides more comprehensive and effective protection for the fundamental rights and freedoms of all persons. And whereas the recommendations of the Constitutional Commission were endorsed by a joint select committee of Parliament and by resolutions of the House of Representatives and of the Senate. Now, I should say we have looked at the joint select committee, that report. We couldn't see anything there which of any significance in relation to section 13.3k itself. KI itself. We haven't been able to track down, but it may be more satisfactory if we were able to track down the Constitutional Commission report, because there appears to be recommendations. And so there obviously were recommendations we haven't been able to track down, and I think we got the impression that the Constitutional Commission had been in discussion for a considerable amount of time. 94. It had been started off in 1994. It finished around 1994, so it just took a rather long time to get their recommendations into force.
And sorry, were you saying that you will obtain that for us, or it's impossible to? You will.
No, well, we haven't been able to get it so far.
But you believe it exists, and you'll track it down for us.
We assume it must exist.
Okay.
But we haven't been able to get it so far.
But they proposed this in 1994.
Yes, Mr. Riley said it was a long time coming.
Well, it may have come early, but it was a long time being implemented.
Yes, it's a long time being implemented, yes. But anyway, you then have the provision, it's introduced, by, I think, by the relevant majority, which is, I think, 2/3 majority, in the second paragraph, under section 49. And you have in section 13 the general introduction. The state has the obligation to promote universal, respectful observance of human rights and freedoms. I just want to emphasise C. All persons are under responsibility to respect and uphold the rights of others recognised in the chapter. The following provisions of this chapter shall have effect for the purpose of affording protection to the rights and freedoms of persons as set out in those provisions. And I emphasise this to the extent that those rights and freedoms do not prejudice the rights and freedoms of others. And I just emphasise that because it's wrong in my submission to read these provisions as somehow providing for an overriding paramount interest for children as against the rights and freedoms of other people who need to be protected from dangerous people. And then 2, the similar effect, subject to sections 18 and 49 and to 9 and 12 of this section, and save only as may be demonstrably justified in a free and democratic society. So you've got as it were, a let-out. Parliament can pass a law, indeed the common law can be developed in such a way as to be inconsistent with these provisions, as long as that is demonstrably justified in a free and democratic society. And then you'll see A, this chapter guarantees the rights and freedoms in 3 and 6, and Parliament shall pass no law, and no organ of the state shall take any action which abrogates, abridges, or infringes those rights. My lords, my lady, pausing there on Lord Stephen's question, I think I'd be bound to accept that if no organ of the state, no court, therefore, could pass, let us say, a sentence which was inhuman and degrading, I think I'd be bound to accept that that must come within the purview of section 2A, subsection 2A.
If I've found the right thing, the report of the committee seems to be quite readily available via Google.
Oh, is that of the Joint Select Committee?
Yes, report of a Joint Select Committee on its deliberations
yes.
on the
that
bill.
is yes. We don't think
that's not what we're interested in.
No, we don't think that has anything of great interest.
Okay.
But the thing that might be of more interest is the recommendations of the Constitutional Commission.
I've got the final report of the Constitutional Commission, Jamaica. I haven't been able to open it.
It's on the 28th of February.
Yes.
So can I just insist, having just looked through the Joint Committee, in terms of the particular provision regarding children, it simply says we agree with the earlier report, effectively, that this provision is required. So it doesn't really show.
Right.
My lords, I can see. We will obviously endeavour to get hold of the actual recommendations of the Constitutional Commission, which I don't think we have been able to get. We did look, haven't been able to get them yet. Just going back to the Charter itself, if I may go over, you'll see subsection 3 on page 240. Rights and freedoms referred to in subsection 2 are as follows. In other words, they're all subject to whatever restrictions in subsection 2. And then one drops down to K. I just want to say something about K on page 242.
Just before you leave that, in relation to 15.2 and the introduction, this is the save only as may be demonstrably justified in a free and democratic society. I mean, would that require a sort of, the equivalent of a human rights declaration? It's a declaration that this act was in accordance with the Constitution, with section 13.2 of the Constitution?
Well, I don't think so. I mean, in other constitutions you do find effectively a provision saying when Parliament passes an act which is inconsistent with the rights, it's got to say so.
This isn't necessarily inconsistent because Parliament's allowed to do this.
Yes.
Where it's demonstrably justified in a free and democratic society. But I've just wondered whether that would be, relying on section 13.2a I'm not saying necessarily this statute, but any others are passed. You're not aware of that?
I'm not aware of that.
That there's been any exercise of that power?
No. I mean, I'm not even sure that Parliament would have to say it's doing that.
Yeah.
But if the law was then challenged, the state could say, well, it was demonstrably justified in a free and democratic society, even though there was no special majority, and even though I didn't say that when I was passing the Act.
Okay.
But just going to K, and well, perhaps I can take it from K. The right of every child. I just want to emphasise one or 2 points on the wording of K. To such measures of protection as are required by virtue of the status of being a minor or as part of the family society in the state, and 2, who is a citizen of Jamaica, to public funded tuition. I respectfully submit that these are quite cryptic words in a sense, because it doesn't quite tell you what the such measures of protection are, for what purpose one asks. And my lords, my lady, the best we can do is so as to enable children to enjoy the protections which are granted to everyone else, and such as they will need because they're a minor if they're not given them. And it may well be, for instance, I don't think I would quibble necessarily with this, that, for instance, the need to keep children separately from adults in a prison and so forth. But it's not specifically talking here about punishment or anything like that.
The concept of measures of protection, is that addressed anywhere?
No, not that I've seen, no. It's speaking generally, but what I also submit is this. One can easily see what it is. Essentially, I would respectfully submit it, obviously bearing in mind, of course, the Child Care Protection Act. What it is saying is, this is my submission, is that Parliament can't go around passing laws, for instance, that deprive children of the sort of protections which have already been granted by the Child Care Protection Act. Parliament cannot do certain things. It cannot deprive children of the measures of protection they are reasonably thought to need. And if it sought to do so, that would be a law which would be liable to be struck down as unconstitutional.
But it may, for instance, cover providing juvenile detention centres
it could do.
Away from adults, because that's a measure of protection that is required.
Yes. Well, I might find it quite difficult to argue against that, yes. But it's not specifically talking about punishment, or indeed about the rights of a child to be a fair trial or anything like that. All that is dealt with in other provisions. This is simply, in my submission, saying that you must make sure children have certain protections. But there's no warrant in my submission for saying protections, that is to say, you should now incorporate, because this is what my learned friend's argument comes to, you should now incorporate the rest of the CRC treaty, or indeed the ACHR, which have never been put into legislation. And I submit that's a step too far, just from these particular words.
Well, the protections in K are, of course, subject to the rights of others.
Yes.
Demonstrably justified in a free and democratic society, which is readily understandable in our legal system. They're not absolute rights.
Yes.
The right not to have inhuman and degrading treatment is an absolute right.
Yes.
And it's just a bit peculiar that right is also subject to a qualification.
Theoretically, in other words, what this appears to be saying is, unless it's reasonably justifiable or demonstrably justifiable, you can talk to someone.
Yeah, well, I mean,
I agree. It does seem. Well, I suspect the draftsman is obviously taking it as read. That is never going to be the case.
But maybe is that the explanation of why 13.6 is because it actually takes that out of
Yes. I think that must be it.
qualification.
But the qualification in 2A is both for subsections 3 and 6 of this section.
Yes.
And I'm sorry, but where do we find the general qualification that rights are subject to the rights of others, etc.?
Well, as far as I can see, in subsection 2, page 240, save only as may be demonstrably justified in a free and democratic society.
Thank you.
And also subsection 1,
Yes.
do not prejudice the rights and freedoms of others. So you can readily understand a limitation on the K, the right of child to measures of protection, in a sentencing exercise where someone's wielding a submachine gun.
Yes.
Yeah.
Yes. I see what you might call the point. How can it be the case that Parliament could ever pass a law authorising torture on the footing that is reasonably justifiable or is necessary? But it may be this is just maybe a drafting point, but in my submission it's so unlikely that would ever happen that this is unthinkable in any event. You have subsection 4 on 243. You'll see the chapter applies to all laws by the executive, legislative, and all public authorities, and then the repetition of the prohibition against torture in subsection 6. I might add, if one goes to section 14 at page 245, if Parliament were to authorise some sort of torture law, it would be difficult to see how that could survive section 14, which appears to be an absolute right. And you'll see also section 14(1)(g), a prohibition specifically directed towards children. No person shall be deprived of his liberty except on reasonable grounds in accordance with fair procedures, except in the following, established by law, in the following circumstances. Then G, in the case of a person who has not attained the age of 18 years for the purpose of his care and protection. The reason I mention that is I suggest that it is difficult really to read 3K as importing, when you have specific provisions which deal with children, such as 14(1)(g), it's difficult to read 13(3K) as specifically being applied to the criminal process, or rather the process of punishment.
Well, right. I mean, I don't think section 14(1)(g) is dealing with criminal punishment. That's taking children into care.
Yes.
For instance, if they're not being looked after by their families.
I accept that, but 14(1)(g) is, I agree, it's not dealing with criminal punishment, but it's talking about when it's specifically dealing with when you can take children away from their parents or not, and things like that. And you'll note, as in the previous constitution, the rights are set out not in general terms, as you find, or not in very general terms, as you find in other constitutions, but in quite detailed terms. Which again, I submit, tells against the submission that one can read all that much into subsection 13(3)(k).
mentioned at the outset of your submissions about reading down. Is there a provision that empowers the court to read down other legislation so that it's not...
Oh yes, well, read down. Section 2 of the Constitution, that is to say, as was in force from 1962 onwards and still is, it doesn't exactly talk about reading down, but it does provide, I think, at 277, subject to the provisions of section 49 and 50. If any other law is inconsistent with this constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. In other words, not otherwise. And that is a point I do want to come on to, because I say, on the proper view, if, let us say, that in certain circumstances, section 20, subsection 2, produces a cruel and inhuman result, you don't knock it out altogether, you read it down. It's not void altogether. It is void only to the extent that it provides for an unconstitutional result. And therefore you have to read down the requirement for 15 years or recommendation for 15 years. I say that's what this section allows for. And indeed other Canadian cases seem to suggest that that's the process that we're going through as well.
How about then K guarantees the right of every child as part of society and the state? That is every child. So you've got two rights. You've got the right of the particular child, and you've got the rights of children in general.
Yes.
And the rights of children in general as part of the society and the state is not to be shot and to be protected from criminals.
Yes. Well, I mean,
we've been analysing it so far on the basis of the right of this particular child, the offender,
yes,
as opposed to the right of every child in society.
Presumably there's a provision that echoes Article 2 of the European Convention. A protection of the right to life, I imagine, must be guaranteed somewhere in this.
Yes, it is.
So the L might help with that.
33.
The right to enjoy a healthy and productive environment. That's free from the threat of injury. In one sense, these rights, everyone's rights are qualified by the rights that are provided, so to speak, for everyone. And if I'm entitled to a life free from the threat of injury, that must have some, the court must be entitled to take that into account in the sentencing process. If one's dealing with, sorry.
Yes, 3A is the right to life.
Yes.
Which imposes positive obligations, at least in the European context. Now, I see it's 4 o'clock.
Yes.
Would this be a convenient point for us to adjourn, Mr. Knox? So if you want to complete a point, we can sit on a minute or two longer.
No, I was only going to go to section parallel universe of section 42K of the 2015 but I think, my lord, my lady, you've seen enough of that to understand what is going on, or rather has gone on since this matter was. The only reason I emphasise that is not because it's directly relevant to this case, but if it is being suggested that the law should be struck down, then I submit you're in no position to do that, if only because of those provisions.
Yes. Well, you can perhaps consider whether you want to take us into the parallel universe. If we're going to do that exercise, it's best done when we're feeling fresher in the morning.
Yes.
Well, thank you very much, Mr. Knox. We'll adjourn in that case.